A leasehold creates a bundle of rights and duties between landlord and tenant. In a leasehold, the tenant holds a present possessory interest, while the landlord holds a future interest, also called a reversion. Tenancy for a term may be created by a lease stating a termination date or a fixed duration. I'll rent the place for 2 years. Great. The termination date is June 1st, 2012. Most states limit the length of a leasehold by statute. Most courts hold that leases for longer than the statutory maximum are entirely void. Hey, the lease is for 150 years. You've only been here for 20. Sorry, pal, that lease is void. I'm out of here. How about a tenancy for a term of 2 years? Let's shake on it. This violates the statute of frauds. Leases creating tenancies for longer than a year must be in writing. Sign on the dotted line and the place is yours for 2 years. This complies with the statute of frauds. Leases creating tenancies for longer than a year must be in writing. Tenancies for a term expire automatically at the termination date. No notice need be given. Hey, you never gave me notice you were leaving. I didn't have to. My tenancy for a term is up. What are you doing? You've not been paying rent. I'm exercising my right of entry. Failure to pay rent almost always entitles landlord to terminate the lease, even without express reservation of a right of entry. Tenant signed a 2-year lease 6 months ago. I want to move out now. Fine by me if you pay the cancellation fee and put it in writing. Surrender. Tenant must relinquish all rights, pay cancellation fee if required by lease, and put it in writing if more than a year remains on the lease. $800 is due monthly. When's the lease end? When one of us terminates by giving the others a month notice. Periodic tenancy, in this case, month to month. Rent is $4,800 annually, payable $400 monthly. Year-to-year periodic tenancy. Rent is $250 each month by the 3rd. Month-to-month periodic tenancy. Tenant's 1-year lease expired June 1st. It's now July 1st. Here's the rent for August. Thanks. Just keep paying every month and you can stay. Landlord's treatment of tenant as a holdover tenant created a month-to-month periodic tenancy by operation of law. Tenant has a month-to-month periodic tenancy. Rent is due in 2 weeks. Here's my notice. I'm moving out at the end of this month. You'll still have to pay your rent for next month. Notice given in the middle of a period does not terminate the lease until the end of the next full period. Tenant is 5 months into a year-to-year periodic tenancy. Here's my notice. I'm moving out at the end of the year. In a year-to-year lease, notice is effective if given at least 6 months in advance. Tenancy at will. We both have the right to terminate this lease at will. Courts will generally find tenant has an implied power to terminate a lease like this. Generally, where the landlord alone is given the right to terminate, courts infer tenant's reciprocal right to terminate. Here's my notice. I'm terminating the lease. Only I have the right to do that. Courts will generally not imply the right for landlord to terminate a lease like this. If tenant has a right to terminate, time to move out, pal. No way, I have a life estate that only I can terminate. Courts generally don't imply one for landlord. Tenant has a fee simple or terminable life estate. This is a tenancy at will, but only I have the right to terminate it. Tenancy at will. Both parties must have a right to terminate. Death of landlord or tenant terminates a tenancy at will. Waste committed by the tenant terminates a tenancy at will. Tenant's attempt to assign his interest terminates a tenancy at will. Sign here and the place is yours. I'll sell you the place I'm renting to T. Deal. Landlord's transfer of his interest in the rented property terminates a tenancy at will. Execution of a term lease on the property by landlord and a third party terminates a tenancy at will. I'm giving you notice. You must move out by the end of this month. I'll just hold over as long as I like. 2 months later, tenant hasn't moved out. This is a tenancy at sufferance. T is a holdover tenant. Pay rent every month and you can stay. Landlord can bind a holdover tenant to a new periodic tenancy. Tenant's 1-year lease expired a month ago. T is a holdover tenant. Landlord can evict a holdover tenant. Landlord evicting a holdover tenant. Get out of here, you deadbeat. Must follow unlawful detainer statute. Self-help is generally prohibited. Landlord binds holdover tenant to new periodic tenancy. For residential leases, the period of the new tenancy is the period of the original tenancy. For commercial leases, if the original lease term was at least 1 year, then the new term is 1 year. If the original lease term is less than 1 year, new term is the original term. If you hold over, I'm raising rent. Given proper notice, T will be liable for higher rent if he holds over and if the amount is reasonable. If T is a willful holdover tenant, landlord may collect up to double rent from him after a written demand. I'm doubling your monthly rent. A lease is a contract between a landlord and tenant, with covenants or promises running between the two parties. Tenant has a duty to repair. Tenant has a duty to use lawfully. And tenant has a duty to pay rent. Here's this month's rent. A growing minority of states add duties. No code violations. Keeping property free of vermin. Using property reasonably. The oven will dry my shirt. Lease covenant to keep quiet. Party! Use of barbecue grills within 10 feet of a building is prohibited. Eviction here is not justified. It must be a substantial or material breach to the lease. Voluntary waste is not permitted. Permissive waste is not permitted. Permissive waste damages. If tenant covenanted to repair the broken windows, he'd be liable for the resulting water damage, but not for the cost of fixing the window. Ameliorative waste is generally not permitted. My clock tower's finally finished. Question. Under the modern exception to the prohibition against ameliorative waste, what 3 criteria, in addition to the property having lost significant value over time, must be met? The 4 criteria to meet for ameliorative waste to be accepted. Property lost significant value over time. Changes made by a long-term tenant. Change must increase the value of the property. And change of property must mirror a change which has occurred in the character of the neighborhood. No fault destruction of property. Is not considered waste, assuming no covenant to repair. Tenant must pay rent until termination, and most states allow tenant to terminate if the property is destroyed. A covenant to repair makes tenant liable to reconstruct even for acts of God. This is the minority view. If tenant covenants to repair, he's responsible for most repairs, including ordinary wear and tear. Use for lawful purposes. Psst, need any drugs? This is a breach of tenant's duty to use the property for lawful purposes. Breach of duty to use premises for lawful purposes. I'm terminating the lease, suing for damages, and getting a court order for you to stop. Landlord may terminate lease, seek injunctive relief, and recover damages. Tenant's duty to pay rent under the common law. Your lease term is up. Now pay up for the entire term. Huh? Rent accrues and is due in full at the end of the leasehold. Tenant's duty to pay rent, modern majority view. First of the month, rent's due. Here's this month's portion of my rent for the term. Rent can be apportioned. 4 months into a year-long lease with an acceleration clause. You failed to pay rent last month. You can stay if you pay all remaining rent now. I only missed one payment. Acceleration clause. Any rent remaining becomes payable in full if and when the tenant defaults on rent. You failed to pay rent last month. I'm evicting you and you owe me all rent remaining. You can't boot me and make me pay. Double recovery by landlord is not permitted. Landlord liens are permitted in some states. They allow landlords to place liens on tenant personal property on the leased premises, or automatically provide such liens by statute. You didn't pay rent and landlord has a lien on this sofa. Self-help measures are generally prohibited. You're evicted. I'll make sure you're out. This is an unlawful eviction. Following a successful unlawful detainer action, lawful eviction. Security deposit from tenant to landlord. Thanks for the deposit. I'm moving out. I kept $100 of it for the broken window. Must be returned to tenant minus property costs. Landlord may keep rent payments made in advance. Here's 6 months rent up front. After lawful eviction or premature termination of lease by tenant. I get to keep the money. Tenant surrender of property. Take the place. Acts as a conveyance from tenant to landlord. Landlord must accept to end tenant's rent liability. Money was due yesterday. Before evicting a tenant, landlord must notify the tenant of the default and provide a reasonable time to pay. Rent's late. You have 1 month. If a tenant abandons property, the landlord may leave the property vacant and sue for rent. See ya. I won't find a new tenant, but will sue for rent already due. If landlord sues tenant for rent, authorities are split on landlord's duty to mitigate. Under the majority rule, I don't need to find a new tenant. But under the minority rule, I have to mitigate by finding a new tenant. In jurisdictions where landlord has a duty to mitigate, landlord must repossess the property abandoned by the tenant. I need to mitigate by repossessing. If the tenant abandons, landlord may terminate the lease, but cannot impose a lien or enforce an acceleration clause against the tenant. I can only get rent already due and damages from tenant. Majority view of landlord's duty to deliver possession.
Someone's in the place I rented.
Not my problem. You have legal possession. Landlord has a duty to deliver actual possession and is liable to T. Minority view of landlord's duty to deliver possession.
Someone's in the place I rented.
Not my problem. You have legal possession. Landlord only has the duty to deliver legal possession to the tenant. Landlord's duty to protect tenant's right to quiet enjoyment. We cannot interfere. There are 3 ways a landlord can breach the duty to protect a tenant's right to quiet enjoyment: actual eviction, partial actual eviction, and constructive eviction. Actual eviction is a breach of the covenant of quiet enjoyment. Ha! I changed the locks. Partial actual eviction by the landlord relieves tenant of the duty to pay rent. But partial actual eviction by a third party means the tenant must pay fair rental value of the portion of the property he still possesses. Constructive eviction occurs when eviction through something that is the landlord's fault, substantial impairment of tenant's use or enjoyment, or tenant must vacate after landlord's wrongful act.
Send a plumber, now.
Nah, I'm busy right now. Constructive eviction, element number 1. Landlord must affirmatively act or fail to act when he has a duty. Landlord is generally not at fault for acts of other tenants or third parties.
I'm gonna rob T.
Landlord is liable to tenant if another tenant commits a nuisance.
Psst, you need any drugs?
Under the modern trend, landlord is liable for acts of other tenants that the landlord has a legal ability to end but fails to.
My neighbor's farm animals stink. You need to help.
I'm just going to stay out of it.
Ah!
Constructive eviction, element number 2. Substantial impairment of tenant's use or enjoyment.
2 days of this was enough. I'm out of here.
Bye, T. Constructive eviction, element number 3. Tenant must vacate within a reasonable time to claim constructive eviction. Caveat lessee, the common law principle, did not require the landlord to provide a tenant with habitable premises. Note, this is not the rule in most jurisdictions today.
I can't live here.
Too bad, you signed the lease. Most states have an implied warranty of habitability, creating a duty in the landlord to provide a habitable premises.
I can't live here.
Too bad, you signed the lease. Tenant's remedies for uninhabitable property must start with tenant notifying the landlord. Landlord has an opportunity to repair first.
I can't live here.
Maybe I'll fix it.
If landlord does not make repairs after notification, tenant may vacate property and terminate the lease. I'm out of here and I'm terminating the lease. Landlord does not have a general duty to repair. Fix this.
No way. It's not part of the lease.
However, there are exceptions. The implied warranty of habitability, repairs mandated by statute, and repairs mandated by the lease. Retaliatory eviction can only occur after tenant asserts his legal rights against landlord. That's fair market for this dump.
You're short.
After tenant asserts legal rights, landlord is presumed to have a retaliatory motive in terminating or refusing to renew a lease or raising rent.
I'm raising your rent from 800 to 1,000.
I'll give you the entire remaining term on my lease. Assignment of leasehold. Under the common law, retention of a reversionary interest. The place is yours until 1 day before the lease is up. Creates a sublease. Under the modern view, reservation of a right of re-entry. The place is yours unless you raise pigs on it. Creates a sublease. Under the minority view, the party's intent controls. Take it until 1 day before the lease expires. This is an assignment.
Agreed.
Under the minority view, this is an assignment. An assignment creates two parties, the assignee and the assignor. I assign my lease to you. The assignor is the party making the assignment, while the assignee is the person to whom the assignment is made. A sublease also creates two parties, the sublessor and the sublessee. I sublease my place to you. The sublessor grants the sublease, while the sublessee is the recipient of that sublease. Let's say landlord and tenant 1 enter into a valid lease. Then tenant 1 enters into a valid assignment with tenant 2, who we'll call the assignee tenant. An assignment creates privity of estate between landlord and the assignee tenant. Privity of estate means that those parties are liable to one another for all covenants running with the land. Let's say tenant 1 enters a valid assignment with tenant 2. We've already learned that there's privity of estate between the landlord and the assignee tenant, who's tenant number 2. But let's add a twist. I promise to be liable for rent. A promise to remain liable creates privity of contract between landlord and the tenant making the promise. Here, the landlord can look to both tenant 1 and tenant 2 for rent. If there's neither privity of contract nor estate, the landlord cannot look to rent from that party. Here, landlord can only look to tenant 2 because tenant 1 did not promise to pay and there is no privity of contract. A sublease occurs when a tenant transfers only part of his lease to another. Privity of contract for a sublease is only with the sublessor, unless the sublessee makes promises to the landlord. Termination of a lease also terminates the sublease. I terminated the lease. But I paid tenant 1. Lease ends, sublease ends. Sorry. A sublessee assumes liability for covenants to the landlord. But this does not mean landlord assumes liability to sublessee. Here's an example of a sublessee assuming covenants with the landlord. Send a plumber now! I never agreed with you to make repairs. Landlord does not have a duty to tenant 2 absent a specific promise. Covenants prohibiting assignments and subleases are strictly construed against the landlord. Also, prohibition of an assignment does not prohibit a sublease. Hey, I leased to T and said no assignments. It's cool. T subleased it to me. Covenants against assignment or subleases may be deemed waived if landlord knows of but fails to object to an assignment or sublease. Hey, the lease forbade assignments. No, you've been accepting my rent for 5 months. Landlord's assignment of rights and interests results in privity of estate between the new landlord and tenant. Condemnation of a leasehold can result from the government exercising eminent domain powers. The U.S. needs to use this property. Huh? If there is a full taking, we need all the property for the full lease term. Huh? The tenant is relieved of rent liability and is compensated for the full market value of the lease. If there's a partial taking, we need some of the property for the full lease term. Huh? Tenant still pays rent, but is compensated to the extent of the taking.